lordships.
Yes.
But the petitioner, being a handicapped person, is a second round litigation blood. Prior to this writ application, this petition has moved the lordships or directed the collector to dispose the representation. Pursuant to this lordship direction, collector had called and appeared a 37A says that agricultural lands should be given to the handicapped person. And Annexure 3, Lordship Annexure 3,
Right. In the first round litigation, the collector was directed to.
yes, appeared. And yes, I appeared there. He heard me, but no response still would have. That is why I have finally also direct the collector to give the result. What is the final decision they are not giving.
Okay, let him give a lawful disposal. Had the submission of fortnight and she conduct then a day. Reputation involved the following prayer. In the course of submission, this court find in the first attempt the petitioner in view of pendency of its representation before the district magistrate cum collector of Keonjhar approach this court for appropriate relief. This court in the disposal of the writ application by order dated 19/3/2022 directed OP3 therein to give a lawful disposal to the request of the petitioner pending at his end. Filing this writ petition, Landed Council, the Patnaik Landed Council for petitioner submits, even in spite of previous direction of this court, there is no timely disposal of the claim of the petitioner, constraining him to move this court again. This court from the earlier disposal find the direction given to collector to take a lawful decision on the application of the petitioner in September 2022. Petitioner here made the averments that soon after the disposal of the earlier writ application, the petitioner even also attended on many occasions the office of the collector Keonjhar. However, there has been no final outcome. Considering innocuous prayer, however, expressing his anxiety for keeping such proceeding pending for such long period, this court directed the opposite party,
collector, that's opposite.
OP number 3, in the event of receipt of such request of the petitioner to give a lawful disposal to the same, but however, entering into desired inquiry, if any, by showing outcome at least within a period of 3 months from the date of communication of order. 3 copy of order be handed over to State Council. Yes.
Item number 2.
There is only to dispose of my petition under annexation number 2.
It's not audible, please.
Self and same allegation under annexation number 2, pending before the OP number 1, in which the petitioner seeks to release the appropriate compensation amount and facilities at par with the land displaced.
Come to annexure 2. What was your request there?
So, release the
Page, annexure 2, page
45 million.
45. Yes, what is the request there?
Requested to release the appropriate compensation.
Compensation, why writ petition then?
Only
Why writ petition? Allegation regarding illegal procedure acquired of our land and prayed for release of actual compensation. Then compensation must have been given. But what? How is representation maintainable in this way? You go under Land Acquisition Act.
Hello.
Maybe somebody else is owner and he has been paid the compensation or she has been paid. Now you people are chasing for the compensation. No representation can be considered.
Hello.
Petitioner wants to, in the course of submission, finding difficulty in entertaining the representation by annexure 2. Counsel for the interest petitioner wants to withdraw the writ application without pressing the representation annexure 2, but I have with liberty to bring the litigation before competent court of law. This, the writ petitioner stand disposed.
Item number 3,
The petitioner filed the Wheeler case number
It's
one.
only disposal of the case.
Yes, ma'am.
It, in the other case, you want
Similar
to dispose has been admitted. What is the position of notice there?
The CD has already given his report. I have annexed it in annexure 4. Thereafter, annexure 2, the demand, annexure 3 is the demand of the RI. Thereafter, the case is not disposal, still pending from 2020.
Okay, considering OLR 804 of 2020 pending since 2020 and expressing its anxiety in long pendency of such proceeding. This is 8A proceeding. So, keeping proceeding under section 8 capital A of OLR Act for such long period, this court directed the authority OP number,
Tahsildar, OP number,
OP number
OP number 2, my lord.
2 to give a lawful disposal to such proceeding. Is at least within a period of 3 months from the date of communication of order. 3, 4, 5 सब से है.
3, 4, 5, 7.
Case number.
Case
change
number
होगा.
ta change.
Case number will be changed. Yes.
item 6,
May I please, your lordship?
Yes.
Matter relating to inaction of revenue authority in confirming the donation in favor of Bhudana, my lord. Similar matters are pending before this honorable court, my lord.
No, pending before this court, but why have you come to High Court again then?
Well,
See,
not-
your second prayer is not maintainable, and first prayer required correction. So Bhudan proceeding is still pending.
No, my lord, they are not taking any action, my lord. Tahsildar is not confirming the donation and declaration.
But you now claim it through prayer number 2, the directing 7 to 10 not to interfere. 7 to 10, these are private parties.
Well, that is a.
So
Yes,
where
sir.
have you stated that a proceeding is pending before any authority?
My lord, I have approached to the settlement authority pursuant to
Where is
liberty granted.
what is that annexure?
Well, that is annexure. Annexure 7, my lord, at page 59. Your lordship may kindly turn to page 72, my lord. Last para, last line, my lord.
Just 1 minute. 72. Yes.
Last para, last line, my lord.
Yes.
The prayer of the petitioner is rejected and claim is also disallowed due to want of Jamabandi in respect of the claim land, my lord. Tahsildar has to confirm the Jamabandi, my lord.
Page 72 you are placing.
My lord.
Last para पढ़ लें.
In view of the above fact and circumstances, as well as after careful consideration of the status report supplied by the Tahsildar Bhubaneswar and field possession report submitted by the court inspector, clarification of the government in R&DM department issued by letter number so dated 13/9/1990, as well as 12/028 R&DM dated 25/4/2014. This court is declined to record the suit land in favor of the present petitioner as per his prayer, and same land
So
was
this has gone against you. Yes.
my lord.
This has gone against you. Then how are you alleging that there is no action by them?
My lord, due to inaction on the part of Tahsildar, my lord, acting under the Bhudan and Gramadan Act, my lord, as per section 13, my lord, he has to confirm the declaration and donation and distribution, my lord.
Where is that declaration?
I have not
Yeah,
got
then withdraw this. Withdraw. Bring a strong.
my lord, he has a declaration is with the Tahsildar, my lord, that has been submitted, my lord.
That has been submitted, then how can, should I not peruse to give a direction?
My
Because you
lord,
have not submitted, so therefore
lord,
there is no.
that is with a single copy that has been submitted by the Budana Samiti.
After vacation, Learned Counsel for the petitioner directed to.
My lord, he has received the copy of distribution and
So,
donation
so
list.
bring it on record, to bring appropriate record.
My lord, I cannot get that, my lord, because
Pardon?
that has already been deposited with the Tahsildar with a single copy from Budan, my lord.
Yes.
I am a grantee, my lord. I cannot get that, my lord. I have only filed a receipt granted by
Why you will not get a copy of that?
My lord, that is a declaration is in a single form, and that is to be deposited with the Tahsildar in original, my lord.
Right, why did you not keep a copy of that?
My lord, that was been granted in the 1961, my lord.
Alright, go to Kama.
53.
Issue notice on the question. You take instruction, what happened? Because as I find, Annexure 7 is a rejection order. All right, the extra copies, adequate number of copies by way of notice. Counter instruction and or counter if any, at least within a period of 4 weeks. Place the matter 2nd week of July. The tachometer. Both the same?
My lord.
Both the matter same?
My lord. My lord, my possession may be protected, my lord, by project.
Possession, this court
government kata
sorry. That's why I said the prayer number 2 is wholly not maintainable. These are against private parties.
My lord, due to non-correction of ROR, my lord.
Who can help you? Go to appropriate court. Go to appropriate court. See, writ may be barred, but you are not prevented from any other source. Yes.
Item 8,
Repetition is entertained only so far as prayer number 1 is concerned. Prayer number 2 declined to be entertained as not maintainable in this forum. For a direction. Yes.
My,
Obliged, my
my limited prayer is, my lord, direction may be given to opposite party number
Yes.
1 to dispose of.
SRP is already admitted.
Yes, my,
Already admitted.
yes, my.
This court record the statement of counsel for petitioner that there has been pleading complete in the SRP 586 of 2019. Okay, considering long pendency of such proceeding, this court to observe in the event pleading involving above revision is already completed. The proceeding should be given a lawful conclusion at least within a period of 4 months from the date of communication of order.
Item number 9, 10, 12 and 13. All are similar, my lord, only
10,
खाली
12,
ये उड़ा
13.
SRP case number उड़ा
Number
change.
change hobo.
आगे,
All right.
obliged, my.
Hela 9 भी गला
10,
10 भी गला
11 টা রইব
11 गला 12 13
12 13 আগে
yes.
Item 11,
May I please, your lord? Well, here, the petitioners have filed the writ petition seeking your lordship by the annexure
What
1.
challenging? What are you challenging here?
Well, I am challenging non-consideration of my objection under annexure
None?
2.
None?
Non-consideration of my objection and on the plea that though the written order was not
In
issued
which
communicated.
proceeding?
Annexure 2,
Annexure 2
consolidation, yes. Annexure 2, your lordship, will page 12.
Hmm.
This is the objection in form 8 was submitted by the petitioners.
Form 8 of OLR.
Minor consolidation, OCSH.
Okay. Then
Prior to that,
consolidation proceeding is operation is still on.
yes, my lord. Your lordship, prior to annexure 2, kindly have a glance to annexure 1.
Annexure 1 there is a decision for
Yes, decision remanding the matter to the consolidating officer. That was done long back in the year 1985. Initially,
okay, all right, it's a remand proceeding.
yes, and the matter was remanded, no decision was taken. Therefore, the earlier another writ petition was filed before this Hon'Ble court. A direction was given for taking a decision within a stipulated time that was passed in the 2015. Still and thereafter in form 7, a provisional publication was made inviting objection, whereby
Where is that publication?
that publication Though I have not annexed, I have.
One,
got-
publication is not filed. To give a trace, at least providing you opportunity. Two, annexure two, where is the proof that you have submitted this?
Annexure. That, no endorsement is there, but you lordship.
Where is the endorsement?
No endorsement is not there.
No endorsement, therefore where is the proof? Why are you not taking care when you file the petition?
But I'm sorry, but the fact remains that,
No, fact remains, how can you say fact remains? I dispute. Court disbelief.
no, my lord, I am not going to annexure two, prefer to annexure two, annexure one is clear.
Annexure
that
one
the
is the
decision-
remand proceeding, there is no doubt.
But may I
So
play?
in the remand that there is a calling for fresh objection, where is the proof? That is not there. Then pursuant to such calling for objection, you have filed a response, that is not there.
No, objection copy এটা মোটা ଥିଲା
No,
ବୋଲି
no,
ଦେଇପାରିଲି।
your filing copy is not sufficient.
ଯୋଉ ଇଏଟା publication ଟା provisional publication copy ଟା
Where is that publication? I know. Because remand order nowhere says it's a open remand.
My lord, may kindly see annexure one that the subject matter of the filing of revision case, page 9.
No, no, don't go there. Annexure one, there is allowing of the revision
Because-
and
because
remand of the
initially-
proceeding, that is clear.
Yes.
But where do you find that this has been remanded with a calling for a scope for party there?
No, no, I was, but my
You are a
ancestor,
party in the revision.
yes, my ancestors also were party, my
Then why did you bring a objection now? The objection must be there in the original stage.
but again, they have made this provisional publication.
So that,
To
so
this, we have submitted objection.
He was not the party.
Hmm?
He was not the party.
Where do you show you are a party? Apurva Shah,
My lord.
you are not a party in the revision. All sorts of confusion, mister. Place this matter after vacation. Counsel for prisoner is directed to bring, to consult the read in establishing his claim that there was calling for objection based on a remand order passed by the Board of Revenue Orissa in consultation revision 1124 of 23 to 83. Being disposed of on 6/4/85. As appears, the objection appended to annexure 2 was filed on 29/3/23. This court finds surprise in the filing of objection to negotiate the petitioner's claim involving the consultation revision 1124/83. Yes, consolidate your brief further. They did. Yes, next.
Item 14,
After vacation ଗୋଟେ date କରିଦେବା। After vacation, ଯେକୌଣସି date ଗୋଟେ କର।
ঠিক আছে 28th of June.
Great.
Yes.
The impugn order is annexure 5, my lord.
Hmm?
The impugn order is annexure 5, my lord, at page 22, my lord. The case, my lord, the original, the case is a game,
Mutation appeal.
my lord.
In a mutation proceeding, what happened?
And mutation was pending, my lord. While the mutation pending, the Tahsildar called for the opinion from the PP, my lord. The PP did not submit the opinion, my lord. For that reason, I approached the appellate authority, the sub-collector, my lord. During pending, the sub-collector passed this order, my lord, directing the Tahsildar to reject the appeal, to reject the mutation case, and also file an appeal before the.
ଆପଣ କାହିଁ ଯାଇ ଧସେଇ ପୋଷ୍ଟ
ଆଜ୍ଞା ନାଇଁ ଯେହେତୁ ବହୁତ ଦିନ ପଢିକିରି ରହିଲା ମୁଁ ଦିନ ଯାଇଥିଲି।
ଗଲେ ଆପଣ କାଗଜ ଦେଇଦେଲେ ସେ କାଗଜ ଦେଖିକି କହୁଛନ୍ତି mutation is not sustainable.
ନାଇଁ ଯେ କାଗଜରେ ଯୋଉ ଡାଇରେକ୍ସନ ଟା ଦେଲେ
ये appellate
ଆଇଦର
authority
ଆଜ
कौन
ଆପିଲ
कहेगी?
ଅଥରିଟି
Where is the appeal memorandum?
ଆପିଲ ମେମୋରାଣ୍ଡum
Let us know for what you had gone to appeal.
ନା मतलब after मतलब
Asal lakha
मतलब
foundation lost. Every case I find.
नहीं नहीं मतलब
ଆମ ଫାଇଲ ଭିତରେ ଅଛି କି memorandum
appeal
of
मोटा
appeal ଟା ଦେଲେ?
मतलब appeal मोटा नहीं तो देखो
Young,
Yeah,
young counsel sitting behind, kindly give way to senior counsels who are standing there. Young counsel in the bench or chair, give some seat. Is it
Indra,
necessary
appeal
to be
memo
called? Yes,
appeal मोटा नहीं
nine. And chutti par aantu. Then who will believe you that, yes, you had only gone for a targeting?
मतलब
Who will believe you that you had gone to the appellate forum for targeting and he
the
has
order
decided on
itself
merit?
the order itself shows my lord.
No.
Let's see can the order in person my lord. The first
appeal memo টা file করো
appeal मोटा नहीं तो सही কথা কই
appeal memo টা
Yeah, let's see the
Let us
first
know what is the prayer there.
the first
There
paragraph
appears there is a civil suit also involved.
Yes.
my lord.
So he has taken, you might have produced all these things.
Yeah, but let's see allow me to some
After vacation, petitioner is directed to place the copy of mutation appeal memorandum based on which an impugned order has been passed. He got the first week of 22nd of June. Yes.
Item 15.
May I please your lordship.
Yes.
The petitioner filed this case for early disposal of the mutation miscase number 29 of
Early disposal, Mr. Ghosh, why mutation cases are kept pending for 2 years?
mutation miscase, my lord.
mutation ଗୋଟେ miscase କଣ file କରୁଛନ୍ତି
Miscase in a mutation case.
Yes.
Mutation miscase. This is the mutation miscase for change of the status of the land pursuant to the government letterment of
So
revenue
this
and
is a
previous.
mutation miscase.
Yes, my lord.
So when the mutation case was disposed,
No, my lord. This miscase has been filed to correction the status of the land pursuant to the government letter, my lord. Your lordship may kindly have glance.
This is mutation case this is the mutation case right? mutation miscase ବୋଲି nomenclature
nomenclated as
ଆଜ୍ଞା,
mutation
miscase ବୋଲି।
miscase. All right. You give a lawful disposal.
ଆଜ୍ଞା।
This repetition involves the following prayer, considering it to be innocuous prayer. Matter stand disposed. Prayer रे भूल लिखुଛନ୍ତି, prayer रे correction କରନ୍ତୁ. In the event mutation, miscase 29 of 21 is still pending before the Tahsildar OP number sole opposite party.
Yes, my lord.
Sole opposite party. Same may be given lawful disposal at least within a period of 3 months. Okay. Free copy be handed over to. At the top lekha on oral request, counsel for the petitioner is permitted to bring necessary correction in the prayer portion. Prayer रे mutation case लिखुଛନ୍ତି, body रे mutation miscase लिखुଛନ୍ତି. Yes.
Item 16.
My lord, Lordship kindly see order dated 8/5/2023. The Lordship had noted not the basic facts. 8/5/2023. That matter where the compromise order was passed by this Hon'Ble Court. The Lordship had noted the petition involved challenging to the order of the mutation authority, mutation appeal not such and such. It appears the authority appearing to be sitting over the judgment of division bench of this court in OJC number so and so, dated so and so. There has been further development by a single bench
Yes,
judgment
have you taken
again by this.
instruction?
ଆଜ୍ଞା ନାହିଁ ଆପଣ ଖାଲି ଏଠି କରୁଛନ୍ତି para 3 ରେ Mr. Ghosh Land State Council at this stage of the matter seeks some time to obtain instruction in this matter. My lord, we have informed them. I am not on that, my lord.
Legal
So it is
aspect,
admitted, legal aspect is admitted, my lord. There is no confusion. The only thing is that, my lord, both the proceedings which have gone against my learned seniors client, my lord, those were in presence of sub objectors. They have been made party in the writ petition. So therefore,
What is the scope for them to reopening? There is a
no, sir, they objected probably on the premises that there is a suit they have filed.
suit has
pending.
nothing to do because government has
But
spent very.
I don't stand, but I cannot stand on the way because the law is well settled. But the question is that ଯେହେତୁ private party ଅଛନ୍ତି ତାଙ୍କ presence ରେ ସେ ଯୋଉ order ଗୁଡା pass ହେଇଛି,
or there is a private party?
yes, they have made them party.
Private party to
Okay, then let notice go.
Lordship.
Issue notice on the question of admission fixing short returnable date.
5 and 6.
5 and 6, right. 1 to 4 extra copy. Any interim order granted?
No interim,
କିଛି ନାହିଁ।
no interim. I have not paid for
এটা
it.
simply ଇଏ ହବ correction ହବ ଆର ବର୍ତ୍ତମାନ ନାଁରେ ଆଉ।
Some fixed date pilot last week of June.
Okay. 30th of June.
Deep
30th
level.
of,
Deep level.
Item 17. Item 17. The informational matter.
Comparative. Nobody is present to argue even in person. Place this matter after vacation to afford one more opportunity. After vacation on 27th of June, the registry is directed to communicate the date to the party in person.
Item 18.
Well, at 18 similar matters, your lordship, we should notice. This, your lordship will find.
Copy ଦେଇଛନ୍ତି କି
Copy
ତମକୁ?
ଦିଅନ୍ତୁ।
ଆଜ୍ଞା କପିଟା ଦିଅନ୍ତୁ।
Have you served a copy on them to find it similar?
That copy I am giving. Only, my lord, your lordship kindly see
No,
the.
copy of order which you are saying.
Only lordship kindly see. Then lordship kindly see this order. Page 28.
Okay. It has been, notice has been issued there.
ଆଜ୍ଞା
There.
All right. Same all.
The lordship kindly fix a date so that. Kindly fix a date. Like other case, your lordship had fixed.
Date ଆଉ ସବୁ ତ ସେଥିରେ ଅଛି date ଦେଖିଲା ସେ ଆର
ନାଇଁ ସେଇ
order
ଡେଟଟା ଗଲାଣି ଚାଲି actually ସେ ଯୋଉ
ନାଇଁ,
ଡେଟ୍
ସେଇଟା
ହେଇଥିଲା 2/3/2023 କୁ ହେଇଥିଲା
କୋର୍ଟ ହେଲାନି ତ ସେଇଟା ଡେଟ୍ ଟା
ସେଟା ଯାହା ହେଇଥିବ ସେଇ କେସରେ ସେ ଡେଟ୍ ହବ
ଦିଟା
along with
ଗୋଟେ-
that would like
ଦିଟା
Place
ଗୋଟେ
the
date.
matter on board after the appearance of parties on 12th of July.
Oblige.
Senior counsel argue କରୁଛନ୍ତି P.K. Mahanti, senior counsel assisted by Pranay Mahanti.
Item 19.
19 you have found this is already covered probably.
କୋଉଟା ବୋଧେ
Mr. Gaur.
19 ଟା
Application
It is covered by these orders.
yes he has just seen ଗୁଡା ଅଛି
These are the batch of cases came other day. You
Aye,
took time to find whether the proceeding
aye.
is covered. ନା ଏଟା ନୂଆ ଆସିଛି?
ନୂଆ
ନା ଏଗୁଡା ନୂଆ ଏଗୁଡା ନୂଆ ସବୁ।
ନୂଆ ହେଲେ ସେ page 12 order cover କରୁଛି ତ?
ଆଜ୍ଞା
ଆଜ୍ଞା
ଠିକ ଅଛି। All these batch.
Item 20.
20 may I please, Lordship?
Yes.
Limited prayer, my lord. Basing on the family settlement, the mutation has been filed before the Tahsildar. Tahsildar rejected. That I have preferred an appeal by the Annexure 3, my lord.
yes
The appeal order was at Annexure at page, my lord, 18.
Annexure 6.
Annexure 3, my lord. Annexure
Annexure
3 is
3.
appeal. Appeal directed
Annexure
to,
3 is in appeal.
my lord.
He
And
has issued
operating portion
notice.
is 18. Appeal directed to appraise, decide the matter to the Tahsildar, my lord. And Tahsildar also decided by the Annexure 4,
Just 1 minute. Where is that direction?
my lord, at page 18, my lord.
1-8.
1-8, my lord.
Please read that para in this case.
In this case, right title in possession of the appellant acquired on the strength of family settlement deed executed by Radha Mohan Das and Sukhasin Das for mutation of its registration is not required as per the version of the apex court. She said judgment para 20.3 in view of the above for the and for the reasons stated above. Present appeal succeed.
He set aside and remanded the matter.
My lord.
Thereafter what happened?
Thereafter, the Tahsildar by its order dated 26/9/2022 at page 20, my lord.
Yes, 26/9/22, what happened?
Passed the order to record the ROR, publish the ROR in my name, my lord.
Yes,
But still till then,
record has not been
no
prepared
publication and
at the submission of. Chhad the thing.
already another similar matter of this petitioner, your lordship has disposed of. I have just corrected the plot number and khata number, my lord.
It is a copy of order. The Annexure 4 to be given
My lord,
to
my
bring
lord,
out a
my lord, my lord.
final order ସେଥିରେ ବି ସେୟା ହେଇଛି
ସେ 3 ଆଉ 4 ର ଡାଇରେକ୍ସନ ଅନୁସାରେ ROR ପବ୍ଲିକେସନ କରାଯାଉ ବୋଲି
ଏଠି ବି ସେୟା ରହିବ
my lord.
Okay,
Necessary.
ଚେଞ୍ଜ କରିଛନ୍ତି ସେ ଅନୁଯାୟୀ ଖାଲି ରଖ ଚେଞ୍ଜ ଇଫେକ୍ଟ କରିଦବା ଅଲ୍ ରାଇଟ୍
Oblige.
yes
Item 21,
My lords, 21, I pray for a direction
just
to.
1 minute yes 21
Well, at 21, I just pray for a direction to Tahsildar Satyavadi. My lords, there small correction is needed in the ROR of the petitioner. Instead of 1 acre, it has been wrongly mentioned as 0.10 decimal. So already assistant consultation officer by annexure 2 has instructed Tahsildar to carry out the necessary correction, but till date he has not taken any steps. So I just pray if a direction be given to Tahsildar, then he will.
the proceeding has been registered
My lord, he filed an application, and pursuant to that, annexure 2. Sorry, my lord, annexure 3, page 12. They stated that on verification of the LR record, it has been found that at the preparation of final error of the village, the area of the plot number 519, acre 1 is wrongly recorded as acre 0.10 instead of 1 acre. Therefore, it is requested to consider the prayer of the petitioner and make necessary correction of the area of the said land accordingly at your level.
it is to be worked out only
To be worked out by the
I
Tahsil.
had submission of respective councils by the annexure 3 this court find there is already direction to the Tahsildar Satyavadi to consider the prayer of the petitioner pending at his end and making necessary correction of the area of the land. Filing the writ application, Shri Mahathi alleges, in spite of such letter being issued on 20th/4/23, there is no final execution of the same. This court find there is hardly lapse of 3 weeks time in between. Petitioners could have waited for some more time. Okay. This would have given a breathing time to the Tahsildar. Be that as it may, the Tahsildar OP number. So it's
4
directed
members.
to
5 members. OP5.
work out the direction. OP5
OP5.
to work out the direction contained in annexure 3 by bringing necessary corrected record of right, at least within a period of 1 month from the date of communication.
My lord, oblige.
Yes.
item 22,
May I please your lordship? My lord, only limited grievance is that the petitioner filed his grievance before the Tahsildar Soro to demarcate his land.
Demarcation proceeding is
My
registered.
lord, he is not receiving the demarcation.
Not
commission,
receiving.
Not receiving. So that I have filed.
Payment
by
receipt. Where is the payment receipt?
Postal
So
receipt
this
is there, my
petition
lord.
involve an allegation by the petitioner that the Tahsildar, which OP?
OP number 1, my lord.
OP1 is not even receiving the demarcation request of the petitioner. Okay, this court finds without entering into such controversy, at this level disposing the writ application direct the OP5. OP5?
OP1.
1,
Yes.
OP1 to entertain an application, if any, filed by the petitioner requesting for demarcation, give a lawful disposal to the same, however involving boundary tenants likely to be affected at least within a period of 3 months from the date of communication, from the date of submission of the demarcation application, along with statutory fees. Yes.
item 23,
May I please, your lordship. But here, Mr. D.K. Mahanti is appearing through caveat.
Ah.
Okay. So I-
Already ଦେଇଛନ୍ତି
But-
copy ଦେଇଛନ୍ତି
I
ତାଙ୍କୁ?
don't find, so that's why I got the copy. I'll solve copy.
Copy ଦିଅନ୍ତୁ ତାଙ୍କୁ.
Okay.
What is this proceeding
But here,
ultimately?
Lord, I have challenged the order of the collector under annexure 6. It is a, Lord,
You challenge order of annexure 3.
annexure 6, my lord, page 34.
Sorry, annexure 6.
Yes. Collector Baleswar, my lord, has declared the sale deed void and
34,
Yes.
35.
yes, my lord, 34, 30.
Where is the certified copy of annexure 6?
My lord, I think.
Where is the certified copy?
Lord, I'll file that. I have that.
You have
I've got,
filed.
I've got that, it is not filed, a Xerox copy has been filed.
But here it appears to be a Xerox copy only.
Yes, yes, certified copy, Xerox file it. Tar Xerox.
No, Xerox cannot be acted.
No, I'll file it. I'll file it.
The pastoral and council
I
appeal
have-
because the petitioner wants to bring the certificate copy of annexure 6 to maintain the writ application. Place this matter after vacation, first week or then.
They are disturbing.
Is
Lord.
23rd.
They are disturbing the opposite party. They are disturbing because.
Why
my
did you
pos-
not file?
Not mine. Tomorrow I'll file it.
Why did you
Lordship.
not file? Just explain.
Inadvertently.
How it is
Inadvertently.
maintainable. At your level, it doesn't
Yes,
look
no.
nice.
I agree.
Now it is
I
all
agree, Lordship.
extreming.
I agree with
Your
the Lordship.
client must be following what are you
Yes.
doing?
Yes, my lord. He is following. My lord. I know that. Tomorrow, my lord, I'll file it. Lordship will take
Day
note. Day
after
after tomorrow.
In the meantime, copy of the application we also served on Sri Mahanti.
No, I've served. Already served.
Already served?
Yes, I have
Just I
already.
received.
Okay,
But,
this court record service of brief on Sri Mahanti, who has already appeared for
Private,
Four.
private opposite party.
Private.
The
Five
petition
and
in the
six.
before the.
3 and 4, my lord. 3 and
3
4.
and 4.
Lord, may I pray, my lord? Other connected 3 matters are there. Can it be taken
Connected
up?
three, sedina memo deyi anantu.
Aye.
But you should not file. Why
Yes, yes.
is so much hurry?
Okay.
Certificate.
Today morning I found that it has-
has. File kar do.
It should have been enclosed with the rate.
Absolutely.
Yes, my lord. That is. Sorry.
Item 24.
Yes.
Here, my lord, my only grievance is that the opposite party number 2 is not receiving my restoration application for restoration of the revision on the ground that the court is not functioning.
କଣ କରାଯିବ ତାହେଲେ?
Let them accept the petition, and when the court will
If
function, that will
there
be
is no
considered.
officer, what to do?
The office can accept the petition.
Huh?
The office can accept the petition. The petition,
Accept କାହିଁ କରୁନାହାନ୍ତି?
There is
Taking up ହେଇପାରିବନି, that's a different thing.
there is no order sheet. Only to restoration application is filed.
So therefore, restoration application if he files, then why office refuse to accept it?
There is no refusal.
court is not
He
functioning.
is filing the copy here.
Only restoration
It was
petition is
rejected ex parte.
No, it was dismissed for default,
dismissed for default.
non-prosecution. Because the,
Dismissed for default.
yes,
Petitioner is absent on call.
yes,
Okay, there is allegation of non-receipt of the restoration application involving restoration of a revision proceeding. Claim to have been filed by petitioner on unfiled annexure 3. Ground of non-acceptance claim to be there is no officer posted to hold such post. Court. Okay, this court observe even there is no officer posted, office must be officiating, and there is no difficulty in receiving such applications. Okay, this court directing receiving such application doesn't may not be amounted to be allowing application. It has to be ultimately considered and disposed of lawfully. Yeah.
Item 25.
Here, my lord, the petitioner challenging the unilateral.
Mic ta set କରନ୍ତୁ ଆପଣ.
Petitioner challenging the unilateral order dated 18/11/22 passed by the additional director land records and settlement under Code of
Annexure?
my lord, under annexure 4, my lord, that the declaring that the Mothasai as a
Just
new
1 minute. 4 is the order or communication only?
No, my lord, order under annex 4, my lord, page 18,
Yes, page 18.
my lord. The BCP proceeding has a already disposed of and directing to the Tahsildar, Kishannagar, to create a new revenue village. Without any
Yes, that is the
opportunity.
direction. Original BCP case record bearing so and orders it are returned to declare its hamlet
Hamlet
a
village.
new revenue village.
My lord.
So how are you aggrieved?
I am the inhabitant of my original mother village, Dulupur, my lord.
ଆଉ ଗୋଟେ hamlet ହେଲେ ଆପଣଙ୍କର ଅସୁବିଧା କଣ?
Totally guidelines are follow କରୁନାହାନ୍ତି ଆମକୁ invitation କିଛି notice କିଛି ନାହିଁ.
You had any objection?
No, my lord, nothing has been done, my lord. Totally notice ନାହିଁ କିଛି ନାହିଁ.
That is all your allegation here. There must be a proclamation in the locality. And you people, must not have given any response. All in a sudden finding this, you are approaching in a writ application. But is your argument that there is no
My
notice
lord,
calling for objection?
Page 9, my lord. No such objection to the proposed changes have been invited, and moreover, where objection are not received, no hearing was taken place. They are page 9, the middle portion of the para.
And this was issued in April 2022.
My lord.
So a hamlet must have been created.
Proper guidelines.
खाली notice कर दिया ला. Issue notice in both, one set. Requisites be filed day after tomorrow. Notice as appropriate karibo.
Stay operation.
Yes, you take. What stay of operation? It was issued only on April 22. So hamlet must have been created. Separate review inspector must have been appointed.
Guidelines have not been followed by the authority concerned.
Any action pursuant to impugned order annexure 4 shall remain ultimately abided by the final outcome in this requisition. Miscase Rava. All right.
May it please, my
Item 26.
Let me see the order dated at annexure 11 series, my lord. Sorry.
Annexure 11.
Sorry, my lord. In page 37 is the order that was passed by my lord. Last paragraph is very important, my lord. Para 4.
Yes.
Considering the petitioner has a grievance required to be considered by Collector Jagatsinghpur, keeping in view the development involved therein, which appears to be in the interest of villagers, this court, in disposal of the writ petition, observes that there will be a decision of the collector on the grievance of the petitioner therein, treating the writ petition as a representation before at least finalization of the bid notification by annexure 1, particularly in respect of serial number.
Thereafter, what happened?
Thereafter, my lord, we have filed the writ petition as a representation, page 39. They have received it.
Then what is the development?
Now, my lord, what has happened without disposing anything or making any decision on that representation? Now, my lord, annexure 1, they have issued this notification, my lord, work order.
But this was issued on 27/4.
Yes, ma'am.
What is the period of work there?
My lord, sorry.
What is the period of work?
Period of work is, my lord, that is period of work.
What is the position of work now?
Nothing has started, my lord. Nothing has started.
Where is your allegation after the writ application? You have not been given consideration.
My lord, page 11, for that, as per the direction of Honorable High Court by 16/3/2023, opposite party collectors would have considered the writ petition as a representation and should have taken a decision by giving due opportunity of hearing to the petitioner.
Who are you, Mr. Patnaik?
Page 11, my lord.
No, who are you?
I am the Panchayat Samiti, my lord. I am the office bearer of the Samiti.
And you are filing in individual capacity?
Yes, ma'am.
Yes.
In Samiti, petitioner is a Samiti Sabhya of Huskana Gram Panchayat, my lord.
Petitioner may be a Samiti Sabhya, but you are filing individual capacity.
Yes, ma'am. My lord, this was the other petition was also filed by him, my lord, where my lord was pleased to pass that order.
All right, but work order is already issued, then who will bear the cost now?
That is there, my lord, that without the sufficient gochar land, if the gochar is not more than 5%, you cannot have any social activities or public activities over there. There has to be an exception.
This involve what construction?
My lord, this involves the construction of that welfare center.
Wellness center.
Wellness center.
Wellness center always in the benefit of the people.
Definitely, my lord. I am not on the benefit.
But then make it clear who will bear the escalated cost, if any.
My lord,
You deposit the amount, we'll keep it in fixed deposit tomorrow, suppose there will be a fresh work order.
My lord, sorry, my lord.
Government has some fund.
My lord, no, I bow down to that. I bow down to that. My lord, what my submission is this, let them take a decision at least.
Now, why is this?
Why they are not
Might
taking a
have taken
decision? After my lord's order also, they are not
They
taking.
might have taken a decision. That's your allegation that you have not been given.
But they let them submit.
Consideration.
Let them say so, my lord, that we have taken a decision on your representation. At least.
Okay, all right, let us issue notice. But no interim order.
My lord.
Notice dita agriculture.
Notice ta interim order upar bhi hai.
Interim order भी notice है.
Acha.
Right. Place the matter at least 1 week after vacation. Counter if any in the meantime. There is specific allegation.
Yes, yes.
Earlier read said yes, this is a complicated issue. Villagers must be involved.
Now, other petitions are also pending where we have filed counter. It was
Yes.
there last week. And it has been filed by Mr. Patnaik.
No, that is different. That is different.
Concerning the same.
No. It is different. It is different.
All right. Dekhiwa. Yes, next.
Item 27.
It's a case, my lords, land in Boriguma, my lords. There, my lords, the land was earlier, my lords, settled in name of Raja Jaipur in an assignment case. But that acre of right could not be corrected, and consequently, my lords, the matter proceeded and settlement authority recorded the land in the name of the government. Thereafter, my lords, the property was purchased, and the purchaser, my lords, referred in Annexure 4, kind of a class page 21, my lords.
Yes.
Annexure 4, before the settlement authority.
15B.
That order was passed. My lords, that order was under challenge before the Hon'Ble High Court in a writ petition. My lords, that writ petition bearing WPC number, Tahsildar challenge writ, bearing WPC number 10875 of 2011. 10875 of 2011. My lords dismissed it on 28/9/2022. Thereafter, my lords, I immediately, after coming to know about the fact,
That were dismissed.
Tahsildar challenged this order, my lords, revisional order.
On merit of 15B.
15B, order dismissed. That is the order, my lord. Then, my lords, what happened? Thereafter, I said that this land should be recorded in my name because I am the purchaser. Then I sent them now online process. I requested them. They said that you institute a fresh mutation case. I instituted a fresh mutation case in Annexure 6. I got that information, but not being taken care of, my lords, that is not being recorded. Now they are going to change the nature and character of the land, my lords.
What is the source of information that they are going to change the nature and character?
Nature and now they included it in the master plan area. That is what, my lords. Earlier, my lords, what happened? In view of this previous settlement, they included in master plan area. That is why I apprehended. I have gone there and they are not saying it. They are.
So 15B is operative now.
15B is operating. Now they have to correct the record of right. They say that they automatically they should have done it. Instead, they said that you file a mutation.
Where is the material to show this has been included in master plan area?
But that the commissioner himself has dealt with that in page 23. And directed Tahsildar to immediately write to see that this should be this last portion, my lords.
Necessary quarter for correction.
Yes, correction.
Now, who is going to change the nature and
Now
character?
the author, because of that has been included in government land and is becoming a part of the master plan area.
So obviously special now, yeah, then my lord, that was Tahsildar and collector. Now after that special planning authority and all these things, they are doing it. But Tahsildar is the competent authority. The status quo be maintained, my lord, that is the thing. Both parties may be restrained not to change the nature and character and not to create third party right, my lords.
How you came to picture?
But I purchased the property, Raja sold the property to third party. I purchased the property from him. Then I filed petition for mutation because on the basis of the assignment, Raja is the king is the owner, but that was not considered. Then I filed the mutation was disposed of on the ground.
Then is it your prayer only limited to the extent for
Correction of
Annexure 4?
Correction of
Annexure 4. Working out Annexure 4.
Annexure 4.
Okay, then that order, if that is not challenged any further,
Yes.
consider the repetition involve the following prayer. However, in the course of submission, prayer has been confined to at least work out the direction by Annexure 4. Appears to have been passed in exercise of power under Section 15B of the OSS Act. In the course of hearing, it has been brought to the notice of the court that state attempted to challenge this order, the 15B order, in 2011, filing a petition in 2011, and this is claimed to have been, and the WPC 10875 of 2011 claims to have been dismissed finally on 28/9/22. The Mahapatra Council appealing for the petitioner contains, petitioner being the subsequent purchaser should get working out orders at Annexure 4 in the fresh preparation of the record of right. State councils, Sri Sahu appearing for the state, though have no dispute with regard to dismissal of WPC 10875 of 2011, but object the claim of the petition on the premises. He has no information as to any other litigation involving Annexure 4 pending or not. This court, while recording that one such writ petition has been dismissed by this court on 28/9/22 in WPC 10875 of 2011, observed, provided there is no lawful obstruction by way of stay of order at Annexure 4 by higher forum. At present, there should be working out of the order at Annexure 4 by bringing necessary corrected record of right at least within a period of 1.5 months from the date of communication of order. With this observation, the writ petition stand disposed.
Item 28.
My lord, petitioner challenges the order dated 16/3/22 by the Annexure 2, my lord, wherein the petitioners have been not made parties, my lord. The fact is that the
15B order to entertain koruni.
no, I am to give an opportunity of hearing to that.
Why this has been decided behind your back?
My lord,
Where do you establish that?
that one my lord, in the petition I have stated.
Come to Annexure 2.
My lord, Annexure 2 is the impugned order, my lord, wherein the allegation that the petitioners had purchased the land in 76.
No, no, you have not been given opportunity. Where do you find that? Who are you now?
I'm the daughter
You are
of the,
Ranjit Mahanti.
no, my lord, we are the daughters, my lord. They are son. The daughters
So
have no,
therefore, your father was there.
but father is dead, my lord. So 76 land was sold.
Go to civil dispute. Go to civil dispute.
In the
If you have
meantime,
a-
there, my lord, in
If you
the
have a inter-family dispute, go to civil court.
in the meantime, like, in view of this order, my lord, the land is being.
Haba, you must be knowing what are the other remedies available. Suit injunction nahi paribeni. Now, 15B, that's why I am not entertaining, because once there is a confusion amongst the family members, it can be settled by only civil forum.
No, not family, my lord. The fact is that, my lord, the father had sold in 76, my lord.
Forget, you create a right, you attempt to have a right through the parent. So therefore, any right comes through, then
Let the Tahsildar may be at least directed to
15
here.
B court has no such
After,
exercise, Mr. Pradhan.
my lord, after 30 years, my lord, the order has been passed. The 77 mutation was settlement
Then
was
you
done.
should have, if you came to know such a procedure.
No,
going on
now
behind your
just
back, you
one
should have
month,
gone there.
my lord, just
Secondly,
one.
you go to civil forum, get your right adjudicated, who deprives you? At the submission of Pradhan and counsel for the petitioner undisputedly. Petitioners, petitioners herein were not the party, not made party in the 15B proceeding, decided herein by the Annexure 2. Taking this court to the pleadings herein, Shri Pradhan attempt to submit that these petitioners have also right over such property. This court in disposal of similar matters, number of similar matters has already come to observe. Dispute intercept parties involving any civil property doesn't come within the domain of the authorities working under Section 15B of the OSS Act. The only remedy in such contingency find to be petitioners approaching the common law forum and getting their right adjudicated through such forum. It is keeping this in view, the petition is dismissed as not entertainable. This court, however, observed in the event the petitioners bring litigation before the civil forum, same has to be adjudicated lawfully.
Certified copy of Annexure 2 may be written. Certified copy of Annexure 2 may be written.
I am deciding on very.
That is to be filed before the authority again.
Mr. Pradhan,
Only substituting
the.
Substituting
Hey,
the.
band karo. Bar needs to be more careful hereafter.
Item 29.
The similar matter already disposed of. In view of Narottama Ratha case. Narottama Ratha case.
Lordship, it is actually, I'm appearing to virtual mode, your Lordship.
Mr. Mishra is there.
Manoj.
Mishra say line ra
Lordship, here actually in Narottam case, your Lordship, there was a direction because the ASOs had suo moto exercised their power, despite there being a case, there being an order of the EDM under the OGLS Act. Here, that is not the matter, your Lordship. This case has never been filed before the ASO for any development whatsoever. So let them take a fresh decision on this miscase that they have filed.
So they have so you want to file a miscase here? So why are you taking advantage of this order? You have not yet gone there even.
Lordship.
So you file your application. You file your application. If he is in authority, then he will take a lawful decision. That's all.
Accept corner. Accept.
So your allegation is not even accepting.
Not accept.
So let him accept and give a lawful disposal.
Lordship.
Question as the prayer as follows. In the course of submission through pleading, it has been brought to the notice of the court that petitioner in his attempt to extend a request for the consideration of ASO Jobra Cutter, opposite party number 2, he is not accepting such application even. This court in several matters has come to observe there is no scope for refusal of application at the threshold itself. It's a different aspect, and every application comes before competent authority has to see the lawful disposal. Okay, keeping this view in observation in view, this court in disposing the writ application without entering into controversy as to whether there is acceptance or refusal at the threshold, permit the petitioner to bring the fresh application before the ASO number 2, at least within a period of 10 days hence. In such event, the OP number 2 shall give lawful disposal to such application. by involving any party likely to be affected and entering into any inquiry so desired and completing entire exercise at least within a period 4 months from the date of application.
8 weeks ଅଛି earlier order 8 weeks ଅଛି
Earlier order 8 weeks. Okay, all right, 10 weeks for me. Earlier order that was a different, that was a remand proceeding. It's fresh consideration, say 4 months.
Oh.
Yes.
May I
It was a
please?
remand proceeding, therefore the court said, all right, let him re-exercise within 10 weeks or 8 weeks. Yes.
My lord, may I please? In this case, my lord, the petitioner is a dealer, my lord. Authorized to sell and purchase gypsum from PPL, OP number 9, my lord. What happened on 28/4/2023? The authorities of OP number 9 convened a meeting in his office and directed the petitioner along with the other dealers to purchase gypsum from OP number 9. He is also a dealer, I am also a dealer. My lord, challenging the same, we have also approved the ADM Paradip OP number 5, my lord. No action has yet been taken. And my lord, what happened?
You are appearing?
Yes, my lord. For OP number 10, my lord. My lord, relief has been sought against PPL. So that is it is a private company, my lord. And what has happened, my lord, the main bone of contention is a new dealership agreement that has been signed between me and PPL.
Who is required to dispose his application? He
My
has
lord,
a pending
ADM,
application.
ADM, but your lordship may kindly see the representation. So it is like the ADM being given the power to decide whom PPL will sell its gypsum.
Let him take a lawful decision.
Yes,
What
my
is the
lord.
harm there? At the limited submission advanced here by the counsel for the petitioner, requesting this court for issuing a direction to the ADM Paradip Jagatsinghpur.
OP number 5.
OP number
5.
5. Okay, Sri Das Learned Counsel appearing for OP 10.
Yes, my lord.
OP 10. Attempt to obstruct the entertainability of the representation by the annexure 10.
Well, copy is there.
You object the entertainability?
Yes, sir.
Hello. Okay, finding a representation at the instance of the petitioner at annexure 10 still pending consideration of the competent authority, this court without expression of any opinion on merit in the entertainability of the same here in the disposal of the writ application, direct OP number 3.
5. ADM 5.
5. To give a lawful disposal to the representation of the petitioner by annexure 10. Also involving parties likely to be affected. Working it out at least within a period of 8 weeks. That's all.
That's it. My
Appearance of Parivar, file question power.
Item 31.
Let the petitioner may not challenge the
audible only.
My lord, the petitioner challenging annexure 9, my lord.
Annexure 9, page.
Annexure 9, my lord, page 40. Sorry, my lord, page 50. The sites.
This is disposal of a representation or a proceeding. 34. 34 proceeding.
No, my lord. The petitioner Panchayat is a newly created Gram Panchayat. Newly created Gram Panchayat, my lord. The petitioner of Gram Panchayat. And the BDO approval the site selection for Gram Panchayat office, my lord, under annexure 1, which is the school compound of the Radha Madhav.
You challenge annexure 9.
My lord.
So that is rejection.
Approved, my lord. That has been approved by the collector, my lord.
Who are you?
Appeal, my lord.
Who are you?
My lord, I am the villagers of the Gram
You are the villagers.
My lord. And earlier the petitioner, my lord, appeared before the honorable court, my lord, which is pending by the WPC number 26512 of 2019, my lord.
Where is that order?
That is pending, my lord.
That is still pending.
Pending, my lord.
Then why are you bringing a new case?
And the petitioner, my lord,
Let's place this matter along with, tell the other case number.
265, WPC number 26512
Please,
of
please
2019,
repeat
my
the
lord.
number again.
Para 9 remains.
Para 9 re mention korchanti.
My lord.
26512 of 19.
My lord.
Okay.
Lordship,
Day after tomorrow along with that file.
Lordship, they have no locus standi to file this petition, Your Lordship.
देखियो आरो केस टा pending अछि.
Lordship.
Okay, they say there is another petition pending. So let both the matter come together. We'll see.
Item 32.
Lordship, here I have challenged the annexure 7, my lord, which was passed by the Tahsildar, even without providing any opportunity of hearing to me, and without the issuance of any notice.
You are a party there.
Yes, in the mutation, it was allowed in my favor. Mutation was effected. Error was granted.
Annexure 7 to again a mutation proceeding.
Again, what a so moto miscase korigi, which is unknown to law.
But maybe he has relied on a civil court decree here.
Not decree, my lord.
Or injunction.
Injunction which was varied by this honorable court in a CAP. So he has initiated it behind my back, got it corrected without providing an opportunity to me. That is why I have challenged.
So that is there is virtual reopening of a mutation case.
Not
reopening of a mutation case.
Annulling the order passed by the
reopening and annulling thereby.
Yes, my lord.
All right, take notice. Private party must be there.
No parties, my lord. I beg pardon, my lord. Here, what has happened? ROR was in the name of a person who had executed a will.
Mr. Das, only make it clear whether this is a proceeding involving a mutation order already there.
That's there, but in arising out of
a party, should it be a party or not?
I was a party in this suit also.
Right.
And since I am not a party
should
here.
it be a party to this mutation proceeding?
Yes.
Then let us set aside and both the parties go there and contest.
My lord, what I respectfully submit.
Then I am entertaining. Today I will not decide.
Your lordship, I don't say that, your lordship. My lord, what I beg to submit, my lord, that the property was.
I'll hear you.
Yes, my lord.
Not at this stage.
My lord, I beg to seek your lordship's leave to file an application, at least because I am not a party, I will intervene. That is my humble prayer.
No, he must be.
He has not made me a party because there is a pending suit. What my learned says.
No. You are the mutation applicant. The annexure 7 has
no,
been
my lord.
in
No,
your favor.
No, my lord.
Party
it was in the name of the predecessor who had executed a will in my favor. And on the basis of the will, the earlier order of mutation which was allowed, that was stayed by the appellate court. Then what has happened, all within a space of 6 months, a suit was filed. Fictitious address of myself was given in the suit. Within a 6 months, my lord, preliminary decree, final decree, mutation, everything could be done behind the back. And thereafter, my lord, a suit was filed by me, my lord, where an injunction was granted. And by that time, since the mutation has been effected.
Already effected.
Already effected, as your lordship rightly pointed out, on the basis of a decree, which is
challenged in another suit.
Another suit, and it's a perceived void, my lord, because.
Right, Mr. Das, am I deciding?
I will file an application.
You are contesting.
Your lordship will not.
You may contest, there is no issue. But why don't you make him party? Otherwise, see, now today you are coming, you are not made party. Tomorrow he may again go against that and file another mutation case. So let us close all these disputes in one go. You also make him a party.
On his oral prayer, he may be implemented.
No, only difficulty will be, this is a statutory proceeding.
My lord.
Okay. In a statutory proceeding, who will be required to be made party?
That is the exactly thing. So unless an application is filed, your lordship.
You file an application.
Yes, I do undertake, my lord, to file an.
Okay. Then pardon asu.
Oral prayer allow कर दें तो मुझे पक्का कर दें मना नहीं.
नहीं orally कहीं करीबा. से आसन
that
material देखेगी कौन तो that he has an interest or stake.
Yes.
I'll get a handle to add him. And all these parties will be involved and ultimately this has to go, Mr. Das. This order has to
Yes,
go.
yes.
And there may be a re-adjudication of the
Right.
proceeding. So therefore, let the other side also appear. Another private party is there.
जे mutation
The second hand mutation applicant.
ଆଜ୍ଞା ସେ ହେଲେ OP number 4
ତାହେଲେ ତାଙ୍କୁ ଏ ଭିତରେ notice କରିଦଉଛି.
ଆଜ୍ଞା
That will solve,
My lord.
at least solve, resolve some time
Yes.
spending. So better to issue notice. Notice issue kar diya na. In this case, notice requisites accordingly kariyo. In the meantime, there should be status quo in respect of the.
Status quo order is already there by the civil court and injunction is there. This honorable court.
IA 57 of 2023.
Yes,
There
my
is a reference of the IA.
Yes, my lord.
So
And my lord friend has undertaken not to transfer the land.
okay,
Yes.
the parties shall ultimately, considering there is already an interim order operating in a pending civil suit by CS 291 of 2023, all these parties shall be ultimately abided by such interim
My lord.
till a final outcome in the writ application. This court here records oral submission of Sri Das claiming to be a necessary party to the proceeding as they are already involved in civil suit involving expeditious disposal of civil suit and they are already operating at the instance of petitioner and they are already operating an interim protection. The Das therefore claim his client na kon.
Pratibha Manjari Devi.
Pardon?
Pratibha Manjari Devi.
Pratibha Manjari
ସେ ତ OP number 4 ଅଛି କରୁଛି ମୁଁ ଆପଣ କରିନି କାହିଁକି
Something nahi ମୁଁ କେମିତି ଜାଣିଲି? You told me that you have not made me a party.
See, Das, since has the instruction to appear for Pratibha
Opposite
Manjari
party.
Devi, the OP number 4, no notice need be issued to OP4 except handing over of one brief copy to Sri Das, who may bring his objection on the next listing of the matter. Posting karo 3rd is 4th of July.
My lord.
I'll serve extra 3 copies on
Yes, state को free copy देबे आ गोटे private party अछि बोधे
से सीए खाली
ये तो जाने
आउ के ना
आ म्यूटेशन किए करथला
आगे म्यूटेशन हम पिटिशनर
माने आपण आगो करथिले 30 टा किए कला
30 टा के 100 मोटो कर देले
समोट कियोटे देइथिबा ना दरखास्त
ना आगे सेति के हेतले तो
Direction was issued from the civil court.
Okay, communication टा हेची
Yes, my lord.
Then he is the contesting party.
She is the contesting party. I have implicated her.
चल आज ही साथ देले नहीं कहेंगे कौन दरकार है
देबी तादर कोन मु देखिनी कोन
ऑल राइट हाँ नहीं ये भी अच्छी तो तनो ठीक है strong parties both side.
Yes. Before I start 33, well, Mr. Bhuya is here. Lordship, that matter. Now the Supreme Court is also saying the investors may be paid back. Can it be taken up before vacations? They have already analyzed all the investors. Khali apan ko order hele, they will start paying. Statutorily, upon khali gote direction hegel, they will start making payments. So the investors are suffering.
Contest अच्छी तनु आसु first week second week of vacation.
I'll mention it. I'll give a memo
second
tomorrow.
week of vacation आसु इटा notice issue तो है नहीं आप copy देबे
is mentioning about that OPID matter.
OPID ro jo apna order karthile for them to find out all the investors of that company and for making
okay payment
payment
issue
payment they have already
इटा कौन
identified.
ये case रे कौन से
नहीं एटा खाली Mr. Bhuya thele bole I mentioned.
इटा आज केन दिमु देबी order तो memo
No, I will file a memo tomorrow.
file a memo then
I ठीक
ये case किए 33 you are there सेरा कौन टंका एपन तो देलेनी
ना टंका order आपन तू हेले सांगे
नहीं नहीं गले से माने आपन सब डिपॉजिट कले
हाँ more than
पार्टी नहीं ना एपन तो पैसा पाई ना कि
के ही पाई ना
आइडेंटिफाई हे जाईची
Identification.
ଆଇଡେଣ୍ଟିଫାଇ ହେଇଯାଇଛନ୍ତି ଇନଭେଷ୍ଟର
ହେଇଗଲାଣି
ଆଜ୍ଞା
ଆଉ ସେଥିରେ ମୁଁ ତ ଡାଇରେକ୍ସନ ବି ଦେଇଥିଲି ଯେ ସ୍ମଲ ଇନଭେଷ୍ଟର କୁ ଆଗ ଦେଇଦିଅ ବୋଲି
ନାଇଁ ହେଇନି ସେଇଟା ଆପଣ ଦେଇଦେଲେ ସାଙ୍ଗେ ସାଙ୍ଗେ they will start paying.
there is a provision under the statute also. We have applied before the OPID court.
OPID
ଆଜ୍ଞା ଆମେ ସେ ଆପ୍ଲିକେସନ ର ଅର୍ଡର ଟା ହେଇନି ଆମେ ଟଙ୍କା ଦବା ଷ୍ଟାର୍ଟ କରୁ
ହଉ ତାହେଲେ ଆସୁ ଆଫ୍ଟର ଭ୍ୟାକେସନ ମେମୋ ଦିଅନ୍ତୁ ଆଫ୍ଟର ଭ୍ୟାକେସନ ଆସୁ ତା ଭିତରେ ଯଦି ସେପଟରେ ଅର୍ଡର
ଅର୍ଡର ହେଇଗଲା ବି
it's only a question of disbursement. Now you may find out Supreme Court is also changing.
Yes, my lords, that is exactly what I said. Supreme Court is also saying
Says
why
how
are they
strange money have come and people are not getting their
payments, my lord. That is exactly what I was saying.
ବାରମ୍ବାର କହୁଛନ୍ତି କେଦିନ ଭିତରେ ଦବ କୁହ କେଦିନ ଭିତରେ
ଆଜ୍ଞା,
କୁହ।
ଆଜ୍ଞା।
So that order will also come to your rescue.
Yes.
His rescue.
We have filed affidavit for compliance.
Okay, but why is not taking these are special courts? Why is delaying?
ସେ ମାଗିଛନ୍ତି ଆମକୁ ଡିଟେଲ ଦିଅନ୍ତୁ କେତେ ଟଙ୍କା ଅଛି
ନା ନାଇଁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ରୁ ପ୍ରେସର ହଉଛି ଟଙ୍କା ଅଛି ଆମ ପାଖରେ ଖର୍ଚ୍ଚ ହଉଛି ବର୍ତ୍ତମାନ।
ଆଜ୍ଞା ଆମେ ଚାହୁଁଛୁ
That is also a thing na now.
ଆଜ୍ଞା କିଛି ଦେଇଦେଲେ ଆଉ ତ କିଛି ସେ ଦେବେ ପୁଣି ଯେତିକି ରହିବ
But maybe 100 crores rupees ଆସିଗଲାଣି already.
100 and he used to provide.
7 is under challenge, my lords. Page 36. This is the cancellation of de-empanelment of grant of registration, my lords. I'll explain the facts, my lords, which led us to file this writ application. Lordship is aware that the government has a BSKY scheme, my lords.
There is no appeal forum.
No, my lords.
It is cancellation of registration.
No, my lords,
or
only
empanelment from BKSY.
Suspension of registration.
BKSY.
My lords, BSKY, my lords, the scheme is like this, my lords. This the patients go to the CDMO, my lords, and the STMO. They send referrals to us, and referrals we upload in their site. Now, my lords, once they come with the referrals, we cannot, there is no, my lords, we don't have any mechanism to inspect whether these referrals are genuine or malified, my lords, or have been created.
But they're having a allegation.
My lords, I'll come
you are
to
only
that.
facing a suspension.
My lord, I'll come to that. Now, once they came to us, my lords, these referral documents we have uploaded in the website. Now, what happens, my lords? The CDMO or the STMO, they don't get back to us.
So, I can't consider at this stage all these things because this is only a suspension stage. I can maximum say you may file an objection, they will take a decision.
No, my lords, what I am submitting before your lordship is now, my lords, what happens because of this confusion? My lords, I am debarred from participating in the BSKY scheme. Now, because of that, they have threatened my lords, 30 Annexure 6. They empanelize us from the BSKY scheme. Now, because of this, they Annexure 7. They suspend me for my clinical registration. Now, my lords, once my clinical
there is definitely some allegation against you.
My lords, no, your lordships may see without a show cause.
You have filed the explanation at Annexure 5. Where is the show cause then?
No, my lords. Annexure 5 is the show cause.
Yes, it is your response. Your response.
My lords, 4 is the show cause.
So where is
5 is my reply for the BSKY scheme, my lords. For suspending me, there has been no show cause.
Right. Therefore, this is a government action. All right, you take notice, no interim order here.
My lords.
But what I mean to say is, it's a suspension stage only.
Yes, my lords.
So suspension is no final punishment.
No, what happens?
Therefore, you have a scope to rectify the or recalling of the suspension order. Why are you keeping this matter pending here?
My lords, they will not recall it. Now, my problem is my entire hospital has been brought to a close, my lords. All the patients I had to transfer at my own cost.
ये चालीची allegation ये जो ये रे आपनकर ये जो समस्तंकर कर दउचंती cesarean. There is cesarean. There is a serious complaint in delivery side.
Yes, fellow.
Everybody comes to the hospital, they go for cesarean.
My lords,
so that there is huge amount.
These are not the allegations against us.
Where is that allegation at least? Where is that allegation at least?
Annexure 7
No, Annexure 7 is there is some allegation, therefore you are suspended.
4 your lordships may see page 32.
32.
Yeah. With reference to the subject cited above, I am to state that your hospital has submitted forged referral documents from SDH, Pottamonday, along with the claim documents for settlement in the month of November 22. Email communications with Superintendent SDM Pottamonday and his subsequent reply have been enclosed herewith for your reference. Therefore, you are requested to submit your written explanation within 7
No,
days.
you must have received the complaint in the meantime. Where is that complaint?
There is no complaint, nothing against us, my lords. That is under the BSKY scheme. We gave our
So
show cause.
you say Annexure 6 is the foundation through Annexure 4.
Annexure 6 is a foundation for Annexure 7. Your lordships may see Annexure 7. Subject is de-empanelment of your hospital from.
So therefore that communication has gone there.
Yes, my lords.
And now they suspend you.
As you know,
but under the Act and the
Clinical Establishment Act.
Nursing Home and Clinical Establishment Act. There is definite provision. This is only suspending. I don't mind keeping the matter here pending, but you will not get any relief until unless the matter.
Lordships, because unless and until.
Therefore, I was from the very beginning saying you submit your explanation to this so that they may take a final decision within 15 days. You don't agree to that.
Then your lordships may say that they take a final decision within 15 days. We will give a reply.
Had in the course of submission, read petition involving a challenge. SC challenge. On koriyo
She tripped Puchi with her.
बसे होनी पंखा नहीं किसी नहीं पंखा टनल लगा एपट कवाट भी खोल दियो in a challenge read petition involving a challenge to Annexure 7 this court find there are parallel proceedings against the petitioner. One undertaken by the competent authority to on the de-empanelment of the hospital involved herein to be slower. To simultaneously, petitioner establishment has also come to be suspended for involvement in the in some sort of allegation to the de-empanelment of the comma पहले बढ़ो जैसे एकदम स्लो रहो हाँ yes it is in the course of submission this court find Annexure 7 simply a communication suspending the petitioner establishment for the timing in this situation for the opinion of this court petitioner must have been served with a show cause involving allegation if any to cancel the registration of the petitioner as suspending the registration of petitioner must be by way of interim measure. Senior counsel Sri Kanun who appearing herein submits even before suspending the registration, the institution of this nature should have been provided with opportunity. Okay, this court considered the allegation to be very serious. Allegation of the establishment very serious. As borne from the record, there is nothing showing receiving of any complaint by the competent authority under the Odisha Clinical Establishments bracket Control of Regulation Act involved herein. Be that as it may, since petitioner only faced a suspension order, it may be open to the petitioner to submit his response, denying the allegation if any communicated to him in the meantime. And in such event, let there be final outcome. Let there be a decision on the as to whether the establishment of the petitioner will be still held suspended. Yeah. Yes, let the, you, probably you are not sure of receiving a complaint or not.
My lord,
You are not sure whether you have received a complaint or not.
we have not received any complaint, my lord.
See,
Your lordship,
there is no service.
after the
complaint
Annex 6, it was Annex 7.
involving the action under the Odisha Clinical Establishment bracket Control and Regulation Act. Complaint involving Annex 7 should be served on the petitioner within a period of 3 working days of service of order. Let the petitioner submit its response to such complaint within 3 working days further. And let there be final decision on the issue involved herein at least within a period of 10 days thereafter. Yes, State Council, Mr. Mishra.
Lordship,
Here there are 2 faceted allegations he is facing.
my lord.
One is some allegation, maybe inflated bills. So a de-empanelment is a different issue, whether you will keep this institution in the panel of BSKY or not, that's a different issue. But maybe merely on communication of this decision of de-empanelment, now the authority working under Act has already suspended, so moto.
Lordship.
So if you find there is no separate complaint, then he must be put to show cause.
Lordship, we'll take a decision on that.
And the foundation may be allegation on de-empanelment. Therefore, advise client accordingly.
Lordship.
Deeply approached. No, not inflated bills. Khali de-empanelment of because they say
সেটা স্বাভাবিক ଥରେ
ଆଜ୍ଞା।
ଯଦି BSKY ରେ KY ରେ allegation ଆସିଗଲା
ଆଜ୍ଞା,
ସିଏ ତାକୁ ଫଟକିନା communication ଟା କରିଦେବେ all authorities କୁ।
ଆଜ୍ଞା।
all authorities ଗଲା ମାନେ ସିଏ ତ ଦେଖିଲା ଆକୁ suspend କଲେ ମାଲ ବୋହିବ ଆଉ।
May I please advise? The petitioner is an elected sarpanch over a margin of 459 votes, and he's a tribal lady.
Now you have come on the final outcome.
Yes, against the final.
Appeal also over.
Appeal has also been over.
Then we have to admit only.
My lord.
Admit her. You are the return candidate.
I am the return candidate. I am
So you have
continuing.
been unseated now.
No, I have not been unseated. During the appeal, I was protected by grant of interim order. I am still there continuing as.
But how can you continue after
Well,
losing 2 forums?
It is only on the ground of he do not know read and write Odia.
Maybe whatever. That's also a
There is
ground to
no
unseat
notification
somebody.
issued. There is no notification issued by the government.
No interim protection. Sorry.
My lord, she is continuing till death. During the appeal, so also till death, my lord. Status quo as on date may be maintained.
Continuance of the petitioner herein shall be dependent on the on the outcome in the appeal. Yes. So ସେ ଯଦି ଆପଣ ବାହାର କରିଦେବେ କାଢି ପାରିବେ.
My lord, till that he has been
What has
protected
actually
during the
saying?
appeal also. During the appeal, the interim order was passed and she is
I
continuing.
don't know how the interim order passed. Once you are found to be disqualified, you should not be allowed to continue for 1 day.
There needs a notification has to be passed, issued by the government. There is no notification issued by the government.
So wait till notification.
During the appeal, at least during the appeal about 6-7 months, the appellate authority had granted the interim order for which there is no notification issued, and till that the present judgment has been passed 4 days back. And till that she is continuing as a sarpanch. She is a tribal lady.
Mr. Samal, I will not grant interim protection here, since you have lost in both forums.
The status quo as on date may be maintained till the reopening of the your lordship may call for.
No, once you have lost in both forums, never the reason mu interim order reason they
No, I don't need any reasoning. Your lordship.
Yes. Notice may be immediately issued, fixing short returnable date. Matter may be placed immediately after appearance of OP number, private OP.
Private opposite party number 1 and 4.
1 and 2. 1 and 2, ଦି ଜଣ କେମିତି ହେବେ?
1 and 4.
କେମିତି ଦି ଜଣ କେମିତି ହେବେ?
That's the 3 candidates who are contesting the election. One was the election.
No, who was the defeated candidate bringing
Defeated
the election
candidate
dispute?
The election petition was OP number 1.
OP number 1. Sooner the notice is served on OP number 1.
Subject to outcome of the
Subject to outcome of the
and the
writ
notice in
application.
the it's also notice in the
Mr. Samuel, is there any necessity of passing order subject to outcome? If you succeed ultimately, your position has to be restored.
if that order will be passed, I may be protected to some extent.
Okay, all right. Any action taken in the meantime shall remain subject to ultimate outcome in the writ application. Miss case dispose main case ଆସିବ, in the meantime call for LCR କରିଲେ.
LCR.
Yes.
Item 35.
35, my lord, limited prayer. My application for recording of recorder right in the name of the petitioner, that was not accepted. For which
Application for?
recording the land in the name of the petitioner.
Okay, this is a petition under OSS Act.
Yes, my lord. OSS Act, that Mauja has not yet been finalized.
Suppose they are not accepting.
Yes, ma'am.
Why are you not sending through registered post?
Registered post, my lord.
Why are you not sending through registered post? Straightway coming to High Court.
Straightway, my lord.
ଆପଣ ତ ପଠେଇ ପାରିବେ ନା ନାଇଁ?
ପଠେଇ ପାରିବୁ, but
କୋଉଠି allegation କରିଛନ୍ତି he is not receiving?
yes, my lord. That annexure 4 that I have given.
No, annexure 4 is the application.
Yes, my lord.
Where have you alleged that he is not receiving?
Yes. Para 7, my lord.
Para 7.
Yes, my lord. However, the assistant settlement officer are reputed to accept the application on the ground that the settlement already
Okay, all
recorded
right.
on that.
Through para 7, it has been brought to the notice of the court that petitioner's application by annexure 4 was refused to be accepted by assistant settlement officer. For the consistent view of this court, there is no room for straightway refusal to accept any application submitted before any competent authority. This court, however, without entering into such controversy, permit the petitioner to bring a fresh application by annexure 4, at least within a period 10 days hence. In the event of bringing such application, same may be given a lawful disposal.
Lawful, taking into consideration of documents and as well as personal hearing.
Yes. Hearing habo definitely.
No, even downance ekdam at the threshold.
You will get a very good ground to entertain. Why are you taking out all these grounds?
Second time, personal hearing maybe.
In accordance with law, that includes everything. Yes.
Item 36.
It's a second content.
36 stage. Okay. So you take out the contempt not maintainable. You bring a contempt if necessary after the disposal of the writ appeal.
This contempt petition has been arising
in the course of submission. It has been brought to the notice of the court that the order of the single bench. ସେଥିରେ କଣ writ appeal ରେ କଣ ଫାଇଲ କରିଛନ୍ତି କାହା order? Writ order 35947. এটা ବି writ appeal ହେଇଛି?
No, my lord, no writ appeal is filed as against this order.
Tahsildar shall show lawful outcome is writ appeal.
କଣ ଦେଇଛନ୍ତି ତ instruction ଆମକୁ?
Are you sure ଏଇ writ ଟା ସେଇ ଇଏରେ ଅଛି ବୋଲି?
ହଁ.
No, but I find here the petitioner is somebody else.
ନାଇଁ ସେଇ ସବୁ ଅଛି.
Devendra Prasad Naik ଅଛି ଆ ଦେହରେ?
He is the number 2.
Oh, he is number 2. Devendra Naik and others.
My lord, writ appeal has not been filed as against this order, my lord. Writ appeal has not been filed as against this order, as against which this contempt petition is filed, my lord.
So verify and bring at least some.
Yes.
Asu, asu for the day after tomorrow.
Neither.
Okay, has been stayed by division bench. However, counsel for petitioner submits writ appeal never involved the order involved herein and wants to bring proof of the same. All right, this court afford one more opportunity to the counsel for petitioner to come ready on day after tomorrow. In the meantime, you also find out this file. Find out from file whether this order is challenged or some order is involved. And ମୁଁ ଭାବି ପାରୁନି ଯେ in a writ Tahsildar is directed to take a lawful decision will be writ appealed.
Your Lordship, if I may intervene, Your Lordship, here in fact, Your Lordship, there was a direction of another order, Your Lordship, that was to be complied by your previous order. So that first order has been stayed, Your Lordship.
So therefore this order may not be there.
My Lord, this order is not there.
Day after tomorrow, let us be firm which order they are pending before the writ appeal court and if we can proceed in this matter.
Yes.
Okay, all right.
Item 37.
Yes, 37.
My lord, that is in fact content. Your lordship may look at page 10. Your lordship's order. It starts from them, the direction is at page 13.
13, yes. In the earlier occasion,
In the earlier occasion, your lordship may keep it last part of the order may be seen. This court observes.
Yes.
This court observes, provided the distribution of Chakka is still pending, nothing prevents the petitioner to raise their objection for consideration of the Tahsildar.
Right. What is the contempt here then?
My lord, your lordship may look at we raised objection. Lordship may look at page 14. He initiated a proceeding, revenue miss case, then passed an order. That is at page 18.
Yes, CR is put up today.
CR is put up today, peruse the case order and judgment of Hon'Ble High Court Odisha in WPC number such as per the judgment. Due process hereby initiated for fresh distribution of Chakka and grievance of any aggrieved person. The list of persons mentioned in will be addressed during the process of distribution and field verification. Your lordship says that before distribution of Chakka, final Chakka, your lordship may look at your lordship's direction again. Final distribution of before the final distribution of Chakka involved, the Tahsildar shall do well before distribution of Chakka and or balance Chakka to take into account the development through Annexure 3 and 4. Now here
I have observed, provided the distribution Chakka is pending.
My lord, your lordship considering 3 orders.
As appears, he is treating it to be a fresh distribution of Chakka.
My lord, he didn't consider it and distributed the Chakka, therefore.
Then why don't you bring in a writ application? Where is the scope for contempt?
My lord, now he has distributed.
So challenge this in a writ petition. You may at best say he is misunderstanding the order of the High Court.
Earlier it was challenged. Your lordship.
So contempt can I interfere in these orders? Contempt I may find if he is moving contrary, I may punish or may not punish. That's a different thing. But contempt can I interfere in these orders?
Now unnecessary public agitation. Lordship may look at it as paper cutting in so much.
If you are so advised, bring appropriate litigation. Contempt will not help you.
As a file a writ application.
Yes, counsel for the petitioner wants to withdraw the writ contempt application in order to bring a writ petition involving the cause of action, further cause of action involved here. Yes.
Your lordship considered 3 earlier writ application, then pass this order.
So you should have brought a writ petition. I had the scope of considering something.
Item 38 for orders, item 38.
I can. You have filed a miss case.
Yes, madam.
Is it a disposed writ petition?
This is OP number 1's petition.
पुणी माइक रु पळेले आपण आजिकली बिना माइक रे किछ हबन
The OP number 1's petition, madam. I have filed this petition for OP number 1. My lord, this writ application is filed.
This is a writ pending or disposed finally?
No, this writ is pending.
Pending.
My
So
lord,
your application for?
Application for Injunction of stage, something. Lordship.
Restraining the petitioner from proceeding with the construction.
Yes, madam. My lord, your lordship see the picture. First picture is my house. This is my parents' house. They have demolished this house.
My lord, sir, before
Your
my-
lordship see, they demolished this house. There's a huge structure is standing. But when I saw this, and by informed and saw this on 26th, I asked him, why you do this? He says that this is my property, I will do. Whatever I will do. My lord, your lordship, see, this writ application is filed for mutation of this suit property. My lord, once this is somehow or other by managed with the Tahsildar and they got a order. Then it is appeal, OP number 1 file a appeal. Appeal it has quashed. Then they file in Board of Revenue. Board of Revenue said that finally published, POTA is finally published, it is not maintainable. Then they have filed this writ application which is pending here. My lord, during the, when they have not stated this, they have demolished the parental house and they started this.
Mr. Patnaik, that is subsequent, that to be considered later on. But first of all, do you agree with this impugned order?
My lord?
Impugned order is dismissed for non-prosecution. So they let the matter be reopened.
Non-prosecution?
See page 12.
Yes.
Page
My
12.
lord, page 12. Read petition.
A revision was brought under section 32.
My lord.
That has been dismissed for non-prosecution by the petitioner.
Yes, ma'am.
So let this order go, the matter go back.
But that is another issue, my lord.
That is the main issue here.
But this
now, in the main issue, you are trying to get an injunction.
Yes, ma'am.
Right?
My lord.
So, what is your right here? What is your right on this property?
Property. I am a sister, my lord.
You are a sister, then go to civil court, get injunction.
That's right, my lord. Your lordship, give me protection, I will go to civil court.
No, I will not grant any protection here. This is 32 proceeding. So there is no scope for interim order here.
My lord, in all the courts they have failed. Now they have come here.
So that's why, as we have already noticed, a forum is elsewhere. So
Well,
immediately rush to that. Why are you wasting your time here?
My lord, that's right, my lord. But till that day,
Yes, State Council.
Your lordship gives some
State Council, let me set aside this.
Lordship, very much.
My lord, that is up to your lordship. But one thing, my lord, give me some protection till I file a suit.
Mr. Patnaik, I can't enter into your scope or right. That's not a subject involved here.
Yes, my lord.
It is somebody is going for 32 proceeding and his proceeding has been rejected. If you want, you may participate in
My
that
lord,
proceeding.
On my instance, their case is dismissed.
So challenge. No, it has been dismissed for nobody is present.
No, that is in Board of Revenue, my lord.
Ah.
They have come up against SDO's order. SDO has allowed this my appeal. SDO has first Tahsildar.
Is a mutation appeal.
Yes, madam.
So take up that issue, we don't mind.
No,
But here this whole challenge is order of the Board of Revenue.
My instance, mutation appeal is allowed. Thereafter, they have filed the Board of Revenue. Board of Revenue somehow or
Go
other.
there, intervene in the Board of Revenue proceeding. Who prevents you?
But that I have appeared there also. But they have not prosecuted the things and they get both the benefit.
The only course is it is to be restored, Mr. Patnaik.
That your lordship may dispose. But till that period, my lord, your lordship give me
Sorry,
some.
your issue cannot be taken care of here.
That's right,
That's
my lord.
that's not in any way involved in the issue involved. So if you so advise, your client may move appropriately.
My lord, he might not, but he has stated that
Sorry,
this is
there's
final
no-
published POTA. This is not
Yes,
maintenance.
it's all right. The main challenge involving the writ application appears to be order dated 14/7/17. Passed by Member Board of Revenue in OSS case number 2733 of 2016. And the order dated 22/10/16 passed in MC Appeal 5 of 11.
My lord,
Mr. Beurian,
My lord,
this is one order.
my lord.
Where is the other order? Where is the other order? 14(7), you have challenged two orders here.
My lords, and appellate order.
Appellate order there.
Annexure 2, page 13, my lord.
Annexure 2, page
13, my lord.
So he has rejected
My
your
lords, it
appeal.
was-
Yes, madam, it was rejected. It was allowed, madam. This appeal is allowed. Appeal is filed by me.
That is appeal under which provision?
My lords, mutation appeal. my lord.
Mutation, huh?
That was mutation appeal, my lord.
Then how can you join both the proceedings here?
My lord.
One is under our Service Settlement Act, another is Service Settlement, though attached but under mutation manual. So these are two different dimension proceedings.
My lord.
So how can you join both proceedings here?
My lords, I challenge the annexure 1.
No, your repetition, come to your prayer.
Prayer is there.
So you confine to one
My-
only.
exactly.
All right. However, in the course of submission, the Beoria Learned Counsel appearing for the petitioner confined to the order at annexure 1 only. Considering the rival contentions, this court find in order dated 14/7/17, the member Board of Revenue has come to observe as follows. Reading the above and finding there is no dispute that the proceeding under section 32 of OSS Act got dismissed for non-prosecution. This could find the nature of proceeding deserves a contesting order. It is only keeping in this in view, and as this court find a valid scope for the petitioner is taken away by dismissal of the matter for his non-appearance. Petitioner deserves to be. Sorry, the request of the petitioner deserves to be accepted. However, your client name, can you tell, Mr. Patnaik?
Anandini Behera.
Anandini Behera. You are all parties there.
Yes, ma'am.
All right. However, while keeping this in view, this court also find for the conduct of the petitioner, there is unnecessary suffering to the opposite parties. 1, 2, and 3. 1, 2, 3, 1 to 4. Yeah. So keeping the suffering of the opposite parties while interfering in the order dated 14/7/17, setting aside the same, this court, however, imposes cost of rupees 1,000 to be paid to each of the petitioner opposite parties, private opposite parties here. Yes. Cost may be handed over to the private opposite parties at least within a period 1 week, based on filing of receipt of payment of cost and the certified copy of order of this court. The matter proceeding will be reopened for there is fresh disposal, providing opportunity to parties concerned required therein. This court direct the Board of Revenue, the parties involved herein to appear before the Board of Revenue on 6th of June and take date of hearing. With this direction and observation, the decision disposed.
Within a particular proceeding.
The proceeding may be concluded. The further proceeding may be concluded within 3 months from the date of appearance.
My lord, some relief, my lord, this is vacation, my lord.
Pardon?
This is vacation. Before vacation, my lord, your lordship give some relief. This is, I think, usual practice earlier.
Relief Delhi though.
No, this is
relief Delhi. Can I give relief to both sides?
No, my lord, it is only for status
Relief is always to one side.
My lord,
And that is called justice to both sides.
My lord, status quo to be amended till
Patnaik, I don't mind. I give relief. This is not a case. But your case is something different, which is yet to be adjudicated in the service settlement proceeding.
That's right.
So therefore, if you have a better right somewhere, go and get an injunction order. And there is also a scope. I don't open it up. It is live streaming. So you find out what is that scope. I have given a judgment. I am just giving reference. I have given a judgment. Wherever there is no scope for interim protection. There are some statutes like Development Authority, OSS, mutation, consolidation. There is no opportunity of interim order. So I have given a guideline that through that judgment, how the position of the parties will be maintained. Please go through that. You will find a support from that judgment itself.
I may be pardon, certified copy be returned to me. The impugn order I have filed with the contempt.
Okay, contempt reserve.
Whether certified. Annexure 1 and 2.
Only.
Certified copy.
Yes, yes, yes.
Item 39.
Yes, this is for orders and why
My lord,
so
my
many senior councils at this hour.
My lord, it's a very simple order. And let me tell you what it is. That the disputes have now been narrowed down. Now I have a power purchase agreement with my learned friend, Mahanadi Coalfield.
Okay.
And if your lordships take this IA, there are two prayers. Page 6. Page 16. My lord, page 16 are the reliefs.
Yes.
The first one is, my lord, pass necessary orders clarifying, modifying the order dated so and so, passed by this honorable court in so and so, directing that the opposite party number 1 to supply coal in terms of the fuel supply agreement dated 26/8/2013. Without restricting to the supply of 100 rakes. My lord, 100 rakes, your lordships are granted as an interim arrangement when the fuel supply agreement was under dispute. Now, after the Supreme Court judgment, it is both of our case. Both MCL and we say that is there. So there should be no difficulty. I think my learned friend does not have any objection to the first prayer. As per the fuel supply agreement.
No objection.
After the objection was, as there was no long-term PPA, this arrangement was made. Now lordship can dispose of the writ application stating that.
Go.
Lordship can dispose of the writ application. Their prayer was to supply coal. Because coal is being supplied. That MCL will supply coal and as per the FSA.
Yes, that's right.
The writ petition can be
What is
disposed of.
the issue surviving now?
No issue is surviving now.
So
again,
this is an arrangement by virtue of
were
any further agreement.
These were arrangements when the fuel supply agreement was in dispute.
Okay.
Now, after the Supreme Court has cleared it, the fuel supply agreement is in place.
So then this is a disposed of writ petition.
No, writ petition is pending.
Writ
It can
is
be
pending.
disposed of. Writ petition can be disposed of.
Okay. Supreme Court case, the dispute resolved in what petition? SLP number can I find from IA even?
If your lordship sees the last order your lordship has passed, everything is quoted in that order.
My lord is 21st of September 2022. My lord Justice Rath had passed the order.
Order number 14 may be seen, your lordship.
21/9/22.
Yes, your lordship.
If your lordship sees, my lords, paragraph 4 of that order, internal page 3.
Yes.
My lords have it, my lords?
Yes, sir.
It appears in the meantime there has been further development in disposal of the appeal involved, and there is also disposal of SLP at the instance of
So
what
I record this only again and dispose.
your lordships have recorded that.
Already there.
Correct.
So I'll rather record that there is no dispute surviving presently.
Your lordship may say that since the fuel supply agreement is now in vogue, as agreed by both the parties.
That is as an outcome of Supreme Court proceeding.
Yes,
Supreme Court order.
And the power purchase agreement also consolidated.
Okay.
There are fuel supply agreement, power purchase agreement. Power purchase agreement, there are 3. So now it has been consolidated.
The dispute was
at the submission of
And there is long-term power.
Mr. Parija for petitioner.
We are both together, my
And,
lords.
Mr. Mishra.
Lord, I am assisting him.
Okay.
No, we are together.
Okay. Then who is assisting?
I'm assisting.
You are there.
Yes, he is assisting.
Both को नाम लिखी दो. आपका नाम हला?
Satyakam, S. Satyakam.
S. Satyakam.
Mr. S. Satyakam with Mr. Parija and Mishra with and Dr. Sharma. In the course of argument involving the IA number 6756 of 2023, there is agreement in the bar that for the outcome in the disposal of proceeding before the Honorable Appeals Court, there has been further development resolving the issue involving in the
My lord.
reapplication in the meantime wholly. Okay, it is in the circumstance as an outcome of the development in the Supreme Court judgment. There has been also restoration of the supply of
Fuel supply agreement.
supply in terms of fuel supply.
My lord.
Restoration of coal in terms
Supply of coal in terms of fuel supply agreement.
terms of fuel supply agreement. Okay, it is in this circumstance, this court find there is no dispute surviving any further to
My
be
lord.
required to be adjudicated in this writ application. This writ application, thus.
Your lordship may only say rights of the parties will be governed by the fuel supply agreement.
Prayer two
Rights of the parties, my lord, will be governed by the
However,
fuel.
while finding no further dispute surviving, the rights involving party involved herein shall ultimately be abided by the
Fuel supply
fuel
agreement.
supply agreement. Fuel supply agreement.
My lord.
In
Fuel
operation.
supply. It is called a
Fuel
FSA.
Supply agreement in operation. Yes.
My lord, there is one more prayer. There is a rollover policy of Mahanadi Coalfield. My learned friend has agreed, my lords, that that benefit will be given to us as it is being given to all other parties.
But all of you are sure that was a subject in the read petition.
Yes, yes.
Yes.
The rollover, interim order was granted by this Honorable Court for rollover.
It was not the subject matter of the dispute, but what my learned senior is saying, that in case of lapse of racks, if other power sectors are being given, whatever facility other power sectors are being given, they can be given, but that is not the subject matter of the dispute. That is not the subject matter of the dispute.
There is an interim order,
The subject as you decide.
All right.
but there is an interim order to that effect.
My lord, my
How
attendance,
confirm कौन the dispute नहीं record है ला
my lord, my attendance may be recorded
for who?
on behalf of OP2 and OP3.
Central government.
No, my lord.
Oh,
They are called discoms.
Or discount.
all right. Nah, please tell your.
My lord, I'm appearing on instructions of DP Nanda Senior Counsel.
DP Nanda.
KP. All right, thank you. How soon?
Pardon, Lordship.